hearing from the community and getting insights and hearing people answer these questions. But
are you one of these
number
people
one,
that walks out? Are you one of these people that walks out and says, "Yes, I'm going to win" because of jury selection? Do you get a sense in voir dire that you have your people, or sometimes you're a little iffy? How confident are you walking out of jury selection?
Very difficult to have your handle on every single one, right? Especially on the defense side now. I'm just looking for 1, 2, 3. I want to get sort of like the warrior in the room. Because oftentimes when you're on your feet, it's such an awesome responsibility to be on your feet in trial. And I love being in front of juries because literally, especially openings and closings, you get to look right into their eyes and you get to talk to them. And you really need to find sort of your representatives in the room. Both sides. But as a defense attorney, you're really either looking for that person to hang the jury on the counts or to be your warrior representative in the room. So it really does become a selection process where you're looking for your people to speak with and really be your representatives in the room.
All right, finish your thought on the other question before I interrupted you. The people coming back saying, "I can't serve." What do you think's behind it, and is there any of it the publicity that is driving that, in your opinion?
The publicity is one of the 3 reasons that we typically see in these cases. I'll tell you, the first one is the facts themselves. The allegations here, mother killing 3 kids. That's going to be enough for some people to have visceral reactions in their thought process about, well, I can't be fair. I can't be impartial. So just on the nature itself, without the publicity, then you throw in publicity on top of that. And because there's so much publicity on it, it runs the risk of prospective jurors going home and either looking at it, hearing about it, talking to family about it. Maybe they come home and they tell the family that they're on a jury or they're a prospective juror, and then the family member has heard about it. And then to your point, that third is availability. Sometimes employers won't pay. Sometimes there are, circumstances in somebody's life that prevents them from serving. So those 3 pop up most, and it's a sliding sort of 3 too, because you could learn more information, although you're not supposed to when you go home. But when you do, you may learn a little more information that provides some problem with your impartiality.
All right. All 3 of those things that you just articulated, they're in play while you were selected, and you were still selected and didn't put up a protest. A day later, I would argue, in Karen Reed, post-Karen Reed, New England, there's a lot of uh-oh feelings, realizing the gravity of this trial by doing a little research. Or a family friend says, "What, you're on the Clancy case?" And that might understandably make people nervous, and they come back to get off. All right, last segment, we talked about the state's Commonwealth's opening statement, what we believe will be the themes. And we listened to the prosecutor go through and basically lay it out, what we expect to be a mirror of the openings, whether it's Friday or Monday. The defense. This is a defense of criminal responsibility, saying that postpartum psychosis was taking over Lindsay Clancy when she murdered her 3 children. Another part of that defense, though, is the medications that she was on. So you have 2 prongs. You've got postpartum depression, which manifests into the psychosis, but then the meds that she was on. They believe that this combination of medication was a part of the equation. Let's go back and listen to both sides talk about the meds and how each side believes they did or did not affect this case.
They put her on a number of medications. They put her on Prozac, which Your Honor is well aware is what's known as SSRI, selective serotonin reuptake inhibitor. Your Honor knows that along with some of these medications, they have the black box warning from the FDA, may cause suicidal ideation, may cause homicidal ideation. She was on Ativan. She was on Benadryl. And then she ended up being told, okay, because she was complaining about the effects of the Prozac, they said, stop the Prozac, we'll find something else. They put her on Remeron. Then they added on Seroquel. And Your Honor, I attached from David Benjamin, the toxicologist, some papers with the submission, and Your Honor can see the side effects that this Seroquel causes. She was having bad thoughts. She was having worsening depression. Her husband suffered through that phase. Her parents were well aware of the fact that she was suffering from this depression and depressive phase. She wasn't sleeping. This is a significant issue between the postpartum depression as well as possibility of postpartum psychosis that is pretty much ignored. But nevertheless, with the overlay of the SSRIs and the history, and Your Honor has some emails and things that people would reach out to me from all over the world indicating that their daughter had the same problem, that they had the same problem. Your Honor is well aware that many times when people are on Prozac or on SSRIs, workplace violence, homicides, family homicides. This is clearly a tragic, which is a word that's used too much in the criminal justice system, but this really is a tragedy, this case.
The police were able to find several notebooks in the defendant's home pursuant to a search warrant, and also notes on her phone that were similar to journal entries. In the months, weeks, and days preceding January 24, 2023, the defendant meticulously detailed her daily activities, her children's lives, her mental state, and her medication use. Her writing was clear, precise, and articulate. She never indicated that she was hallucinating, delusional, or had disordered thoughts or speech.
David Bruno, how does medication factor into the defense?
Oh, it's important, right? When we were talking about the forensic psychiatrist, what are the facts that they're going to rely on to come to their opinions? And we're starting to hear history, right? We also heard from the defense attorney right there in that clip about the toxicologist, which is going to be another expert that comes in that talks about the medications and the side effects and the causes and how they may react together. Right, so we're going to layer the forensic psychiatry on with the forensic toxicologist that now could start talking about those medications, those complaints to the doctors, and start to build some of this building blocks, foundation to come to those opinions that are going to be so important. Because ultimately, when the defense is on the closing and they're up in front of that jury making the arguments why she shouldn't be criminally responsible, they have the experts to back them up. And the experts are only good as the facts that they rely on. So it's a building block that they need for the experts.
How does the defense get around the fact that other people, because they're using it to their advantage, well, other people have told us that their daughter suffered this, they suffered this, but those people didn't kill their kids, likely. We don't have a lot of stories like this, a mother killing her children because of postpartum psychosis. How do you marry that and to the jury with a straight face saying, yes, Lindsay, it happened to all these others, they were able to get around it, they felt it coming on, she did not. She's responsible. That's their argument, that she's responsible because she didn't manage. Yes, she had some mental health issues, but she didn't protect her children.
Yeah, great point, Ted. I mean, first of all, those emails to the defense attorney, they're not coming in. That's not the type of evidence that experts are relying on, but there are going to be
You're right, they're not coming in because Kevin Reddington tried to get them in. He tried to get a couple people to come in and testify, and that was shot down. So
not coming in because it's, you know why? It's not the type of evidence that experts rely on. The type of experts they rely on are published papers and research and data and things like that. So look, this is not a new topic, right? So there's definitely going to be a lot of history on these medications and how they react to each other. It's going to be the toxicologist and the psychiatrist to come in to explain these things to jurors. That's why we have experts, because we need experts to explain things like these medications, how they interact with each other, and the mind and how the mind works, and whether or not psychosis or postpartum rises to a level of insanity.
Yeah, we're going to get a break, and when we come back, we're going to talk to an expert who knows all about what the defense is trying to get this jury to believe, postpartum psychosis. That's next.
Your house might not be a mansion.
Welcome back to Court TV Live. I'm Ted Rollins. We are in Plymouth, Massachusetts, as jury selection continues in the case against Lindsay Clancy. There's a live look inside of the courtroom where prospective jurors are being individually voir dired to see if they will sit on this jury of 18. Right now, there are 16 seated, 2 more needed. 10 women and 6 men have been seated. The process continues. There's also a 2 o'clock motions hearing, which we will cover here at Court TV. Defense in the case against Lindsay Clancy is pretty basic. They plan to mount the defense that she's not criminally responsible, that her actions are not legally, criminally responsible. Why? Because she was suffering from severe postpartum depression and psychosis and was heavily over-medicated at the time of her children's death. What does that mean, really? Well, yesterday I spoke to somebody who knows a lot about this subject, clinical and forensic psychologist, Dr. Lindsay Clancy. Take a listen.
It is extremely rare to have postpartum psychosis. Depression, much more common, although still rare. But psychosis happens in about every 1,000 births. And it's not considered a mental illness per se. It's a psychiatric emergency. It means that you have lost touch with reality. You are not in control of your brain. Your body has dropped all of the estrogen as that placenta leaves your body. And you are in full-blown psychosis, largely with delusions where you're believing things that are not true, and hallucinations. You're seeing things, hearing things, smelling things. And in this case, it sounds like the worst hallucination, a command hallucination, someone telling her to do something, to the point where she feels like maybe her babies won't go to heaven unless she ends their lives. So it becomes so twisted, and there's no way out of it if you're not medicated properly.
Dr. Dobson, we should note, is the host of the podcast Intentionally Disturbing with Dr. Leslie. From your standpoint, do you believe her? Given the facts of this case, 3 kids dead in the basement with exercise bands, something's wrong.
I'm going to tell you I believe her, and it's because this was preventable, and this is why it makes me so angry. We have systemic failure, family failure. After her second child, she showed signs of bipolar and mania and excessive exercise, and she was erratic. That means when the 3rd kid comes along, we need to be hyper vigilant about her mental state. I don't think she should have left the psychiatric facility she was in, and they pushed her out. My guess is because they didn't have bed space because it's so underfunded. And then she lands in a clinic that is not at capacity for somebody who needs to be in a residential facility, who needs to be hospitalized. There were so many moments where she tried to get help and where people tried to help her, and it just kept failing. And then the polypharmacy involved in this case, which psychiatry will heavily speak to, is obscene. I have never seen something like this before.
We just saw all the medications that she was on at different times leading up to her children's death. How disturbing is that? What kind of a factor is that in this entire picture? The medications she was on and off, and changing the dosage of.
I think it's massive because usually we have postpartum psychosis with a rapid onset within 2 weeks of birth, but this was 8 months later. If you look at the trajectory of this woman's mental state over those 8 months, we are layering on more and more disorders, more medications, more confounds, and we're not helping her. She's getting worse. She's manic. She has insomnia. And then this confabulated psychiatric medication is, if she has bipolar and she's mania and you're giving her uppers, it's going to lead to psychosis, which it did. So if she had any hope, it was in those final moments where they would have medicated her correctly. But it led to a full-blown psychological break, and then the hallucinations took over and she killed her children.
What's in your experience, most common reception of lay people when presented with this type of scenario? I know on social media a lot of our viewers are, I don't care, she killed her kids, she's got to go to prison. Where are we as a society in terms of accepting, listening, and discerning this type of manifestation of a mental disturbance?
Your word discernment, I think, is perfect, because I think that's what we're lacking. We have to discern what is actually happening, and there's no win in this case. There will not be a win. This is a lady who will probably get NGRI, not guilty by reason of insanity, and spend the rest of her life in a psychiatric facility, which I don't think is any better than prison. Both are horrible. Psychiatric facilities may be worse. I worked in the same place that she is in right now for many, many years, and I have my own trauma from it. But she's not walking out free with this defense. She is going, it's harder to get out when you don't have an end date in a psychiatric facility. With prison, you actually do. So most prisoners end up leaving sooner than individuals committed to state facilities because of not guilty by reason of insanity. Or in Massachusetts, it's criminal responsibility.
Yeah, and a lot of that is because they're evaluated and there's reluctance to allow someone to leave those facilities because it could be just a wild card what they do. Her affect in court, straight ahead, doesn't seem to react to anything. Does that surprise you? Is that common? What's your take on her affect in that wheelchair?
Yeah.
I would assume two things are going on: that she's heavily medicated because she's probably tried to end her life multiple times within the state facility. I'm sure that will come out in trial. And she's sad and depressed and in shock that this is happening, because once you come out of the psychosis and realize what you've done, how do you live your life as a mother who killed her children? Why would you have any affect at all? I would be utterly numb.
All right, some insight there from somebody who knows. David Bruno is still with us, former prosecutor, criminal defense attorney. What do you take from the doctor's conversation that we had yesterday?
Hey, look, that's the type of expert that the defense wants to put on the stand and explain. You know, I bet you're going to hear something very different from the state's expert, and that's where the battle of the experts is going to take place here. But what I'm hearing in that interview is, again, history. Okay, there seems to be history, and that's good for the defense because, you know, when we're listening to the communications that the prosecutor is proffering at that arraignment and what we expect to be the opening statements, very goal-directed behavior, communicating with the husband through text messages, telling him to do certain things. So that the defense has to explain, how does there become a break? And this is the type of expert that the defense will call to start to talk about the history of this particular defendant, as well as the type of research and other things that are seen in the research and the published articles.
Yeah. Any chance she takes the stand?
Doubtful, because when we talk about experts, the experts are able to testify to things like her statement. I think that the defense is going to be able to get through the experts everything that they would need from her on the stand. It's just because of the nature of the case. Every expert can't just bring wholesale defendant statements in. But this is one of the rare circumstances where a forensic psychologist, like we just heard, or a psychiatrist can rely on that independent objective testing and also the statements from the defendants. So I would imagine that they're able to do what they need to do through the experts instead of calling her to the stand in this case.
All right, let's get a commercial break. Lindsay Clancy, the jury selection process continues in Plymouth, Massachusetts. We have our team on the ground there. Sierra Gillespie inside the court room. And there's a motion hearing coming up next hour or two, or about an hour and a half from now, which is going to be pivotal. We'll watch that together. Lots more coverage as we continue the case against Lindsay Clancy on Court TV. Stay with us.
The defendant is a danger to herself and others. She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom.
Before January of 2023, Lindsay Clancy worked as a labor and delivery nurse in Boston. Now paralyzed from a suicide attempt following the death of her children, she sits on trial for murder, with her defense framing the tragedy as a total medical failure. But prosecutors believe the initial cuts that Clancy gave herself actually weren't all that severe. What does it mean?
He went to their bedroom on the second floor and the door was locked. He was able to open it, and when he looked inside, he saw blood on the floor in front of a full-length mirror and the window open. He immediately runs downstairs and into the backyard, where he finds the defendant laying on the ground. She appeared to have cuts on her wrists and neck, but he stated to 911 that those wounds were no longer bleeding.
David Bruno is still with us. David, this idea of a suicide attempt, that it helps, one would think, the defense in the theory that she didn't have some ulterior motive of just, I didn't want my kids, or the kid, I wanted a life without kids. She tried to take her own life. The Commonwealth, on the other hand, was going the other way with saying that she really didn't even try to kill herself, that the cuts on her, the wrists, were superficial. Now, the defense has a much different theory. Take a listen.
We all know that this is an individual, as Ronna knows from reading Dr. Raycard's letter, who is in dire medical condition. We all know that this woman is, as counsel concedes apparently, a danger to herself. I question whether she would ever make it to a trial. She's suicidal. She's extremely emotional. However, she's unable, and has been unable, to express any happiness or sadness or cry.
David Bruno, this idea that she didn't really attempt suicide, that the cuts on her wrists were superficial, that's risky, is it not, for the Commonwealth to present to this jury when you have the defendant sitting in a wheelchair?
Yeah, I mean, unfortunately, for a prosecutor, you take it like it is. You know, those facts are in, and those superficial wounds are in. You know, but again, there's questions there about, you know, if she's in this psychosis, why stop? Why only superficial? Why not actually complete the suicide? These are going to be great questions for our experts as they come on this stand on both sides, because it's almost like, you know, what I talked about with the communications going both ways. You know, there's pieces of evidence that always can cut both ways, and each side is going to use them as to how the experts direct them to use.
During the hundreds of cases that we watch come through here on Court TV, whenever you get one that's the battle of the experts, I have found that most times the battle is a draw, that both sides come up with really good experts, and it leaves you thinking no one clearly wins the battle of the experts, and that the preconceived notions of a juror going into that battle usually win the day. Is that accurate, and is this case different maybe because it is so complex and jurors maybe don't even have an opinion formed, given what the defense is saying, that this postpartum psychosis, which is what, to many people, is really at play? Your thoughts?
I'll tell you, Ted, when we talk about battle of the experts, it really is a battle. In essence, look, they are limited to, you know, the facts that they rely on. But there are those exceptional experts that roll into the courtroom and just demand respect, and they show their wisdom. And the best example I have is Dr. Martin Tobin that we saw in the George Floyd case. I mean, that was the pulmonologist that came in and talked about the oxygen and brought those diagrams and these exhibits, and that was just somebody that had the jury. He just came across so credible. And when we talk about those types of things, about what expert to believe, it's going to be the one that is most credible and could educate and show their wisdom and experience.
Yeah, it's going to be fascinating to watch play out. That is for sure. David, stand by. We're going to get a break. When we come back, a special hour of our coverage of jury selection in the Lindsay Clancy case continues. We'll be checking in with Sierra Gillespie. Julia Janae will be here. Don't go anywhere. Back with more of our continuing coverage from Plymouth, Massachusetts, right after this.
Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us and following along as we have all our eyes on Massachusetts. The question is, was it murder or mania? A mother there is on trial for doing the unthinkable, taking the lives of her 3 kids before then jumping from a 2-story window, severely injuring herself. The Lindsay Clancy case has garnered immense attention, bringing to the forefront questions about maternal health, mental health, and criminal responsibility for the person who was supposed to care the most. We have been paying attention to this jury selection that has been happening there now for the 4th day. And we're going to get you a live update from there on the ground. We have Sierra Gillespie joining us. She's the host of Scandal, the podcast on Law and Crimes Network. And Sierra, I understand that there has been some movement. We were moving backwards at one point in terms of getting to 18 jurors. What is the latest?
Wow, we have had quite a day so far, Julia. Let me tell you, I mean, this morning we had 1 juror left to be seated, then 2 jurors were dismissed, so all of a sudden we needed 3 jurors. Since then, 2 more have been seated. Literally just moments ago, another woman juror was seated. She's retiree age, an older woman, and that means we only need 1 more juror seated. And here's what's interesting is hearing from the defense after we had those 2 jurors dismissed this morning, which was a big surprise for everyone, by the way. I spoke to the defense and they were saying, you know what? Honestly, jury selection could continue into tomorrow, Friday, meaning that openings would likely then be Monday. At this point, it's still kind of up in the air if we get that 1 final juror, but I guess we'll have to wait and see.
The mood there. Typically, we don't see backwards movement in jurors. Yes, there's always a chance that a juror can get sick during jury selection and they then have to keep the process going. But to have this kind of backwards movement then forward, I mean, this has actually been happening throughout jury selection. The first person who kind of did a take back was earlier in the process. What do you sense from these attorneys? Even the courthouse staff sometimes can feel the tediousness of this process.
This is unlike anything I've ever seen before, to be 1 person away from seating an 18-panel jury, and all of a sudden 2 jurors are dismissed. We're going backwards instead of forwards. I mean, it was a complete shock to everyone in the courtroom, and the defense has been pretty outspoken with reporters, you know, in and out of the hearings, and I could just sense kind of the defeat here. Like, oh my God, come on. I mean, I talked to Kevin just a couple of days ago, the main defense attorney, and he said, I'm ready to do openings today. That was, I believe, on Tuesday. Now we're here on Thursday. He's ready to kind of get the ball rolling. And I think there's just exasperation in the courtroom because we're talking about some really severe things, right? We have to talk about mental health. We have to talk about 3 children allegedly being murdered, at the very least talking about how they were strangled to death. I mean, these are really heavy topics. And at this point, I think people are just kind of exasperated. Like, let's get the show on the road. We don't want to talk about this anymore. Let's start with opening statements. So I think people are kind of in the hurry up and wait camp right now.
Sure, especially when you have a 6-week trial ahead. No doubt the judge wants to make sure this starts in a timely fashion so that it doesn't push out much longer how long this case may take. We understand not just we're anticipating the seating of that final juror, but we also have this motions hearing that's coming up this afternoon. And I understand from your reporting, Sierra, that that's going to happen whether or not we get the 18th juror. Is that still the case? And what do we anticipate happening at that motions hearing?
Yeah, it's this motion hearing that is really kind of putting a kink in the hose, so to speak, because if it wasn't here, we could just finish jury selection today, and then tomorrow could be opening statements. But we have this really, really important motion hearing at 2 p.m. that is happening no matter what, so I'm told. And this hearing is based on a motion that Patrick Clancy himself filed on July 20th. And essentially in this motion, he was asking that major exhibits from photos of the children, autopsy photos, all the way to the 911 call not be released to the media. Only the jury could see them. And of course, the 911 call would be played out in open court. So reporters could, take it down and transcribe what the words were said, but not record on it. Now, the media is saying we want our hands on that 911 call. At the very least, we're interested to hear what happened. Most of the time, when some sort of alleged crime happens, we get our hands on the 911 call right away before even we get to jury trial or conviction or anything like that. So it's rare not to have the 911 call. And this is something, it's really big because Patrick Clancy says, you know what, this is emotional for me. If this 911 call is out there in the world, in the zeitgeist, it will be there forever. I'm already going to have to go on the stand and talk about these really gruesome, tragic, horrible things. So to have that living out there in the ether on the internet, it's just too much for me. Of course, the media is fighting back on that, but I will say, according to the Boston Globe, there is talk that Patrick Clancy himself will be here for that 2 p.m. motion hearing. So, you know, I'm going to be in the courtroom to let you know.
Yeah, certainly. It's understandable that that's something that he may want to keep out, but some things are public record, and we'll see how the judge rules on that. We're also getting word, our team is telling us, Sierra, that the judge says that they want to get a jury by lunchtime, or before that motions hearing happens. I don't know if that can be something that is mandatory when these jurors are coming in and it just is based on their questions. Have you noticed the tone change? There are times when it is getting more difficult in jury selection. You will then hear the court be a little bit more stern with the jurors and even stern with the attorneys in the length of time that they're doing the questioning. Are you seeing any shifts in the way this questioning, or I know you can't hear everything, but how it's going?
I mean, so far, I will give credit to the judge. He seems very even-keeled. He doesn't seem like he's annoyed. He doesn't seem like he's upset that he's repeating these same questions over and over throughout the individual voir dire. And I think, to his credit, he's really trying to make sure and guarantee that we have an 18-person impartial panel of jurors. That's really the most important thing here. And as we've seen, there have already been multiple who have been taken off. We don't want that to happen once the trial gets underway. So I think they're being extra meticulous at this point just to make sure that nothing like that happens again in the future. But I will say you can kind of sense from everyone, they're kind of tired. They're kind of ready to get this going. And honestly, it's about 1 o'clock right now. This is usually when we break for lunch. So maybe they're just going to push through in hopes that we do seat that final juror.
Oh, really good insights. Sierra Gillespie, thank you so much for sharing all the details with us. I know you will be back to give us updates. We're all anticipating that final juror will be seated, so we'll let you get back into the courtroom for that and that motions hearing that we are waiting for. While we continue to wait, let's bring in a panel of experts that we have to talk about this case and help us break it down. We have with us forensic pathologist Dr. Priya Banerjee, also criminologist Dr. Debbie Goodman, and criminal defense attorney and former prosecutor David Bruno. So good to have you all on today. David, I want to start with you because I am imagining what these attorneys must be feeling. Those qualified jurors, the ones that were seated, those are ones they didn't want to use their strikes on. So in a sense, those were people that they felt would be good jurors, and finding quality jurors isn't always that easy.
No, it's not, especially, the allegations themselves about a mother killing 3 children. The publicity is a factor that goes in. I talked to Ted last hour about, getting information, then going home and talking to a family member and then learning more about that, or a family member having their own opinions that may affect the impartiality of the prospective juror. But for attorneys, too, prosecutors need to plan their witnesses. There's so many logistical things that go into trying a case that I don't think our courties understand about scheduling and getting these experts who typically are around the country. So logistics are very, very difficult. The defense, on the other hand, well, they just cross. The defense attorney's ready to rock and roll in that opening statement, and then who's the next witness? And then rocking the cross-examinations. They have less of a interest in scheduling than the prosecutor does until they have their own case. And then that brings their own logistical issues. But when we don't know the start date, and we're working through these jurors and these strikes and these people that are now withdrawing from the pool, it has a number of logistical issues for both sides.
Sure. Logistics aside, Dr. Debbie Goodman, this is one of those cases that has layers of issues. So when we're speculating about what jurors may be struggling with, potential jurors may be struggling with the most, it could be multiple things. What's your overall analysis of this case as we're just starting our discussion about it?
Certainly. Thank you. Good afternoon, Julia. You are absolutely right. There is so much to unpack here. And the way I see it thus far, we're going to have three main areas of focus, first of which, of course, is the factual evidence. This individual is alleged to have participated in a triple homicide of our most vulnerable victims of society, children, little Cora, Dawson, and Callan. Next, we're going to need to look at the medical side of this case, meaning the contraindication of the medicines that she was prescribed, upwards of 13 different types of drugs, and the interaction of which and what may potentially have, counteracted the other. And again, do we know with certainty, did she take the medicine with regularity, scheduled doses and such? And then the last piece that I see is going to be the mental health aspect. We dial back, Julia, 25 years ago, Andrea Yates, very similar, right? With a mom of 5 children, drowned each of whom in the bathtub, seemingly started with postpartum depression, which affects, according to CDC and WHO data, 1 out of 10 women. However, the postpartum psychosis, of course, is more rare, less than 1% of women worldwide. And yet, for me, at the moment, there is this time window of both cases that I think could potentially be the tipping point. This seemingly, 50 to 55 minutes of Patrick leaving the home, at which point Lindsay allegedly killed the children. I think this was a murder-suicide, or that was the intent.
Dr. Banerjee, you're a forensic pathologist. The medical examiner, no doubt, is going to be on the stand in this case. What's going to be most compelling for you as you're watching this case? Because we have a situation where we expect her defense to admit to the homicide, but not to the intent for murder.
Right. So, from a forensic pathology standpoint, it's going to be a very emotional and difficult set of cases to present. These are 3 deceased children at the hands of the mother, and that process is not being denied, right? So she has to sit there, as well as the jury, as well as the audience, all focusing on these horrific acts that were done in a cluster of time, like all together. So I think, when you see photos of children's bodies being presented, it's going to be quite gruesome. And I think it's going to be challenging. I don't think the cause of death of the kids is really an issue here. I think obviously the psychiatric aspects of it, which are external, which is another separate piece of the puzzle and external to my area of specialty, is going to come at hand. But then I think the jurors will have a hard time separating themselves from the gruesomeness of the killings to then the psychiatric aspect of it.
Yeah, and this is a separate issue, but in that motions hearing that's going to be coming up at 2 p.m. that we will be able to take everyone inside of, we know that there's some objections from the father of these victims to those images becoming public. It wouldn't be something that we would share on court TV, of course, but there is an objection for it even being shown in open court, but we know the jury has to see them, which makes this all the more difficult. David Bruno, as we wait for this final juror to be selected, I'm wondering, just because there was this maybe concern, we have a concern as viewers watching it, that jurors will be coming in and wanting to change their mind or add to why they can't be a juror. Do you think there would be any benefit of bringing them in, since they were selected one by one and not all at once as is done in some jurisdiction, to getting them in there and making them take that oath? They haven't been necessarily sworn in as a jury panel yet.
Yeah, when they get their number. I mean, obviously they're struggling with the number. And by the way, that's 6 alternates. Those are a lot of alternates. That's on the more than normal alternate line. So they want their number, and for good reason, right? Because there are 6 weeks. They're going to be going home. There is a risk of a juror hearing something. So I think it's good that they're going with the 6. Just one additional thing I think all of our courties need to understand, too, is when we have these psychiatric cases, this first part is going to be the prosecutor proving their case beyond a reasonable doubt. They're not going to be calling the forensic psychiatrist right away. They have the burden. So they got to establish each of the elements in each of the counts first. Then when the defense puts it in play in their case, they're going to try to establish their defense. And then the prosecutor comes in with their rebuttal, and then we'll be hearing from the prosecutor's psychiatric witnesses. But it's not just all about mental health initially, although we'll be hearing the theme of mental health and goal-directed behavior or medications throughout. But there are parts to this case that have to come in the way that they do, and the prosecutor has to prove the case first before we get to affirmative defenses.
I'm so glad you mentioned that, because there was even a motion by the defense trying to bifurcate this trial. They wanted to separate the guilt phase from the mental health, the insanity phase. That was denied by the judge. It's very atypical that something like that would happen. So this is going forward as all at once with this panel of juror. Our panel of guests are standing by. We've got to get a break, but those jurors that we're talking about, they're not just going to be hearing evidence from inside of the courtroom. They'll be taking a trip during this trial. And when we come back, we'll talk about where they are going and whether or not the locations in person, seeing them in person, is going to make a difference. TV Live right now, jury selection continues in Massachusetts, where they're on a quest to get 18 impaneled jurors in the case against mother Lindsay Clancy. Now, there's also a motions hearing that is scheduled for 2 p.m., but the judge at last check said that he wants to get those 18 jurors before they even go to lunch. So we'll keep an eye on that. They are really working to get to that number of 18 so those opening statements can begin. Now, while we continue to monitor what's happening there, let's focus on what jurors will see at trial outside the walls of the Plymouth County Courthouse. Now, last month, the Commonwealth of Massachusetts, they asked the court to approve the transport of jurors to 3 different locations.
I was approaching it as most of these types of cases that I do. We usually let the homeowner know when we'll be there. They make sure they're out of the home and it's unlocked. We go in. A case like this where we have 18 jurors, maybe send them in groups of 4 or something along those lines to see whatever myself and defense counsel want them to take note of, and then leave the premises with an instruction to the jurors they're not to open any closets or anything like that or touch any personal items. And I think that's pretty much what's encompassed in the order, if I recall.
Can I ask that the court at least limit the police presence? I mean, I have had it with police officers on motorcycles buzzing back and forth next to the jury bus, and police officers stopping traffic and blue lights behind you, blue lights in front of you. There's no need for that type of a police presence in this case. We're going to take a bus to a house in a residential area in Duxbury, and that's it. I understand that there may be a need to, I guess, I don't know, close down a road or something, but I would ask that we don't have such an overwhelming police presence for obvious reasons.
Come on. We could go to sidebar. We do have a plan in place, but for security purposes.
Sure, yeah. Is he sidebar?
Ultimately, the judge approved this motion for a jury view. So the jurors will be taking that trip to 3 different locations. Number 1 will be the Clancy home. And here's a portion of that motion, as the prosecution asking for the jury to observe on a view these various locations identified. And they say it's important to understand specific issues to help this jury so that they will have to determine, including things that they will have to determine, rather, including the time and distance between the locations at issue. Let's bring in our panel to see what they think about this case. We have with us Dr. Debbie Goodman, Dr. Priya Banerjee, and David Bruno. So good to have you all still along. Let me start with you, Dr. Goodman. What do you think is going to be the benefit of having these jurors inside of the Clancy home? They don't own it anymore. Other people live there. They've had to get the logistics of allowing this entry into a home that 3 years ago was the scene of an alleged crime.
Right. I'm in agreement, Julia. I think it is important for jury members to go to the scene of the crime when a judge allows it. They will have a sensory idea of what transpired. Yes, of course, they'll see the imagery and the gruesome graphics in the courtroom, but once there is the external lens on this case, I think the full sensory development of what potentially this mother did to her 3 children in that window of time when, again, in my eyes as a criminologist, she specifically from 5:15 to 6:09 had her husband leave the environment so she could kill these children. I think that's going to have a very significant impact on this jury.
Criminal defense attorney David Bruno, defense doesn't often want jury views. They don't want the jurors to get too intimate a connection to some of this evidence, but sometimes they are in favor of it. It just depends. What's your thought on this particular jury view? Is it necessary?
I don't think it's necessary, especially because of the changes. I mean, oftentimes when we want to bring people through the crime scenes, have there been any substantial changes? I mean, this is a new owner. Who knows how that house has changed? With that being said, this is for the prosecutor. This does help the prosecutor because it's going to bring emotion, more emotion than ever, for that jury being in the place of the 3 children being murdered, as well as, that gap, that errand that was requested of the defendant for her husband to go and pick up the thing from the CVS as well as the food. And that long travel and then that long delay, it goes to a little premeditation there, sending him away at a long period of time so she can do what she did. Certainly very, very relevant as to the distance and the time for the prosecutor.
Now, while we're still talking about the home, as perhaps will be the #1 stop when these jurors are on this view, here's a look at more from this motion. There's something else they want these jurors to see, not just the basement where this horrific thing happened. They also point out this. So on January 24th of 2023, it's alleged that the defendant brought each of her children to the basement of their home, where she then strangled each one with an exercise band before going to her bedroom with a knife and attempting to cut her wrists and neck. The defendant then exited from the second-floor bedroom window and landed on the hard frozen ground where her husband and first responders found her. Inspection of the inside and outside of the home will assist the jury in understanding the evidence and events of that night. Dr. Banerjee, I know forensic pathologists sometimes want to have that outside evidence when they're doing their autopsy. Sometimes they just want to look at the actual body. Here, jurors are going to be in that home, outside of that home. Do you think seeing the window and perhaps the distance from that fall is going to be compelling or helpful to them?
Well, I think it's going to help the prosecution, if anybody. You know, in my career, I have gone to many a crime scenes, and, you know, it puts the crime and the personal connection much more, it makes them more real, right? And imagining the 3 children in the basement as well as this window, I think even though the decor and the setup is different, which is a very valid point, I think, you know, understanding the organization of the house, accessing it, feeling as if you were there, and the steps she took, I think that's going to be a real doozy for the jury.
Now, there will be a 3D model that's also part of all of this, and I think we either have video of that or a clip of the prosecution talking about that in front of the judge.
The other thing we had talked about last time was that the 3D model was, I'm not sure if that was done or if that's an issue now or.
It's almost complete. I'm expecting to, Sean Marucci from our office has been working on that, and as soon as it's done, provide a copy to defense counsel in the court to look at. But it's going to be a digital monitor that's on the screen.
So it's a digital representation of the house?
Yes, a digital model of the home. It'll have an exterior view, and then it'll have each floor of the home. And it's just a digital model, nothing physical.
Dr. Goodman, I'm actually going to talk about something that David just mentioned, the other 2 locations that this jury is going to go to. The CVS, where Patrick Clancy was sent to by his wife on an errand for medication for their child, and then the 3V restaurant to pick up food. This is part of what they say was this very specific plan, and they want these jurors to feel the distance. They want them to drive it and to understand exactly what that time and distance feels like. How do you think that will impact them, if at all? Is it prejudicial for them to drive it when they'll have the information? They could even have the map in court.
I don't think it's prejudicial, Julia. I'm all about the facts and the evidence. So whether we're talking about DNA, whether we're talking about these exercise bands, the length of time that Patrick would have left the home, traveling to the CVS, traveling to pick up the food. Again, thus far, in my mind as a criminologist, we really do, I think, have the 4 elements, right, of first-degree murder: planning, premeditation, willful with malice. So I think it's important for the jury to get the totality of what happened here, and that will be obtained via this drive and this location glimpse.
Yeah, and David, can you explain to our viewers this evidence walk or this view that they are going to be on? They're not allowed to talk. The attorneys aren't allowed to talk. There's not really a showing of evidence, right?
Absolutely, right? This isn't a Q&A. The attorney's not going to be able to ask their questions of any witness while doing this. So you already hear from the defense attorney, we don't want a spectacle. Apparently, he's concerned and complaining about a number of law enforcement vehicles and emergency vehicles being around the jury, either when they come or they leave. So obviously, this has to be done in a way that's going to be impartial, to not influence the jury one way or the other. We just want the jury to see, we want the jury to feel, we want the jury to see the distance between the two, and there's not going to be any room for argument or questioning during that process.
That jury view, it's going to be very interesting for these jurors, no doubt. Anytime they get out of the courtroom, it's going to be an undertaking by everyone involved there at the courthouse, but it certainly is something that may be helpful to them. Our panel is staying with us because we have to get to a break, but when we come back, we're going to talk about the burden of proof in this case. Who has to show that Lindsay Clancy did or did not suffer from a mental crisis? The prosecution or the defense? Don't go anywhere. Jury selection, or voir dire. It's getting close to wrapping up in the murder trial for Lindsay Clancy. The Duxbury mother is accused of strangling her 3 young children back in January of 2023. She's pleaded not guilty, while defense attorneys cite severe mental health struggles at the time. They say she doesn't have the criminal responsibility for these deaths. And the defense wants the judge to read a preliminary jury instruction once this trial starts that explains to them the shifting of the burden of proof to the Commonwealth when it comes to a case about mental illness.
Your Honor, when you give the instructions to the jury on the law after we've picked the jury, and I believe you do it before openings, in light of the fact that it's obvious that lack of criminal responsibility is the defense, is the central bedrock of the defense in the case, I would ask that the court would, in addition to instructing the jury, as you do in a generic sense, about proof beyond a reasonable doubt, that the court would also instruct the jury that as it relates to the burden of proof, in the unusual situation where you're dealing with lack of criminal responsibility, that it is not the defendant's burden to prove that she was lacking criminal responsibility, but in fact, upon presentation of evidence, it's the government's burden to prove beyond a reasonable doubt that she was not acting as a result of a mental disease or defect. So I'm just asking that you would add that to the generic instructions.
All right. Como?
Your Honor, similarly to the argument that the Commonwealth was objecting to the criminal responsibility being mentioned in the statement of facts, we would also object to the preliminary instruction, full instruction about criminal responsibility, because as my sister said, it is the defendant still has to raise it, and they have to raise it not just by saying it in an opening statement, they have to raise it by expert testimony, lay witness testimony, or the actual facts of the case. And so that isn't done until the case is underway, and preliminary instruction it comes well before that.
What if I instructed the jury in a sense, almost like hypothetically, that it's anticipated that the defense of criminal responsibility is going to be raised? If that's raised, this is what the law is.
Well, I would suggest that we don't want to be caught in a burden shifting situation on a preliminary instruction, so maybe that language is a little bit too close. I think it's either Your Honor gives it as it is in the model in the preliminary as a preliminary instruction, or it's not to be given and just to be addressed at the conclusion of the case.
Right. I generally give it. I understand the Commonwealth's position, but I generally think it's a good, well, I'll just leave it at that. I generally will give that, so I'll take a look at, but I generally give the model language that's suggested.
All right, let's bring in our panel of experts. We have still with us forensic pathologist Dr. Priya Banerjee, criminologist Dr. Debbie Goodman, and criminal defense attorney and former prosecutor David Bruno. David, I'm going to start with you on this one. Let's talk about what's typical and what's atypical for even Massachusetts, but there's a burden shifting in certain cases, even though we always say it's on the prosecution to prove beyond a reasonable doubt, but there are also defenses.
Yeah, absolutely. Look, it's what I was breaking down before, too, in the parts of the case. First, proof beyond a reasonable doubt of the allegations themselves. Now, in Massachusetts, the case is a 2016 case, Commonwealth versus Dawson. And what it says is they just have to raise it. This is not a very high standard by any means to raise the defense of insanity. Once it's raised, then the Commonwealth has to disprove that beyond a reasonable doubt. So the defense clearly wants to get that out in front of this jury. If this is going to be a mental health defense, they want that jury understanding that it's not on them to prove the mental defense beyond a reasonable doubt. No. Once it's raised, it's the prosecutor's burden, and that is a very, very critical burden that they need to know. And I agree with the defense attorney. I agree with the judge. They should be out in front of it because we know where this is going in the case.
Dr. Goodman, let's talk about what may be in the minds of these potential jurors, because if they hear that the prosecution has to prove that she didn't have a mental illness or that she didn't understand right from wrong, how do you think that shifts things for them to even hear it that way, especially when we know there's going to be evidence of her actively seeking out treatment prior to this incident.
Right. I think there could be a shift one way or the other because we know the prosecution is coming in very strong with the evidence that Ms. Clancy is alleged to have strangled her 3 children. So that they're going to demonstrate. Next, can they demonstrate potentially this was a murder-suicide based on her behaviors after? I think yes. Now, the issue about the mental health, I think the concern or consideration has to be, can somebody with a mental health defect or circumstance still understand the wrongfulness of his or her conduct? You see, I'm going to, in most of these cases, say yes because it's so rare, Julia. We're only looking at the data and the fact-based evidence of insanity in our country. Less than 2% of individuals going through the court system are declared mentally insane, which would mean they didn't know what they were doing and they didn't know what they were doing was wrong at the time. So at the moment, I think the prosecution is coming in strong to suggest that Ms. Clancy knew, in fact, what she was doing, knew what she was doing is wrong because she sent Patrick away for at least 50 to 55 minutes so that she could do what she did, sadly, tragically, to Cora, Dawson, and Callan.
It really seems like a very thin line that these jurors have to figure out outside of all of these really horrific details. Dr. Banerjee, we've mentioned it. A medical examiner is going to be on the stand. The prosecution will call, even if the defense is accepting that part of the, let's call it the guilt phase. Yes. But is there anything in the medical examiner's report that you think will actually help the jurors understand whether or not the person that carried this out was in or was not in the throes of a psychotic break?
I think that's really difficult because when we're doing autopsies, when I'm doing them, especially in homicides, which these are classified as, you're taking it as a very objective situation. You know, these are going to be carefully examined children. You're going to, document the ligature marks, which is this exercise band, and that's a very forceful act. So I think the impact of the autopsies and the photos with the addition of the descriptions from the ME testifying will make it an uphill battle for the mental capacity ruling, because it's not an instantaneous death that you get in these kids. You have to hold that strap, and it's seconds to minutes of losing consciousness and then irreversible brain damage in each child, right? And so that's going to be pretty graphic, and I think that's going to be a huge burden for the defense to come up with that it wasn't as purposeful. I don't know how they will use that purposefulness, that planning to get each one down to the basement, then carry it out individually. That seems to me in some ways very purposeful and organized. So I think that to me is going to be the difficulty to overcome. But the autopsies in and of itself will be graphic, will be very emotional, but will be sort of looking at the objective data from the bodies of the children. Something that's going to be so difficult. We mentioned that motions hearing. That's going to be the topic of discussion coming up at 2 p.m. Jury selection is still going on. David, Dr. Goodman brought this up a little bit in terms of comparing this case to other high-profile ones. She mentioned Andrea Yates, which I think is one that was almost a start to a bigger conversation that hadn't been had before, and now we've had 20 years removed, much conversation about postpartum, maternal health, these issues. And I'm even thinking of a case that we covered here on Court TV, the one of 20-year-old Chloe Driver, whose daughter, Hannah, a baby, that she was involved in a cult, and that's what was alleged, and this jury convicted her of being in a cult. They weren't allowed to get certain medical and mental health treatment, but that she was suffering from these ideations and ultimately slit the throat of her baby. The jury found her guilty but mentally ill, so she is getting treatment behind bars. With these high-profile cases, do you think that helps jurors to better understand some of the issues that are going to come out versus if this was 20, 30 years ago where it was not as talked about?
I think the high-profile cases bring awareness. I think that, proactive approaches to all of this for women that are experiencing these symptoms and identifying them and getting the right medications and treatment and counseling. I think that's what the high-profile nature of these cases bring. It's not necessarily going to be helpful to the jurors. I mean, the jurors need to be fair, impartial, and they're going to be following what they hear from the forensic experts, the pathologists, the psychiatrists, so the psychology. It's that is what guides this. But there is a benefit to bringing awareness, certainly, because the more we talk about this, it does raise the awareness to the community as to look out for these issues so we can prevent this in the future.
Well, we have got to fit in our break, but Dr. Pree and Dr. Goodman, I want to get your thoughts on that. So we're going to keep talking about it on the other side. We're also waiting for that motions hearing that's going to happen in less than 20 minutes to see what's going to be argued and what we can expect at this trial. Don't go anywhere.
If you're happy and you know it, clap your hands.
It's the
Welcome back to Court TV Live. We are continuing to follow what's happening in Plymouth County, Massachusetts, where two things are going to happen today. According to the judge, they want to seat that final juror so that there is a jury of 18 by lunchtime, and they also are going to have a motions hearing at 2 p.m. So we are standing by for that to happen, about 13 minutes away from these attorneys and the judge all coming in and talking about some final things. And one of those at issue has to do with who we anticipate is going to be the first witness of this case after those opening statements. And that's going to be the ex-husband of the defendant and the father of the children who were killed, Patrick Clancy. His testimony is going to detail a lot of the events before and after this tragic event in their home in Duxbury back in January of 2023. But at this motions hearing, Patrick will be there with his own attorney, and he is going to be contesting or objecting to the public sharing of the 911 call he made. It's something that has not been made public yet. It's been under seal, so we haven't heard it, but prosecutors did describe what's on that call.
When EMS arrived, he asked them to stay with her so he could go find his kids. The 911 call kept going. Patrick can be heard on the 911 call entering the home and heading to the basement. At one point, he calls out, "Guys." He can then be heard screaming in agony and shock as he found his children. His screams seem to get louder and more agonized as the time passes.
Our panel is still with us, Dr. Priya Banerjee, Dr. Debbie Goodman, and criminal defense attorney David Bruno. David, what do you think? Is the 911 call coming in? It'll come in as evidence, no doubt, but is it going to be under seal away from the public?
Yeah, I mean, this is a new thing. I mean, we saw it in the Tyler Robinson case, that preliminary hearing about these layers of publication. And look, it has to come in. I mean, that is extremely relevant evidence. And then the judge is going to have to make a careful decision. I mean, we're listening to victims' family members more and more. I mean, there have been a number of very important changes to our law to give victims rights and their participation. And now we're even starting to hear from lawyers representing victims in hearings like this. So it's going to be a careful and very difficult decision, but at least we know that the jury's going to hear it, because that's really what's most important. And then the judge is going to have to balance those interests of the husband.
That really is the most important thing. We will be following what happens in that motions hearing. Dr. Banerjee, I want to actually go back to something that we talked about before the break, because I could see you nodding. I wanted to come to you, but we were out of time. But we were discussing some of the issues in this case, and I wonder if you think there are any issues that need more awareness in the public, or if it's helpful that now we do discuss some of these issues a lot more.
Absolutely. I mean, maternal health overall and maternal mental health, I think needs to be further studied, and more awareness is never a bad thing. Unfortunately, I feel like the saddest outcomes is what propels this topic into the media. And it's always so prevalent. I know personally, when I was postpartum, I had severe anxiety that my baby was going to die. And so, I never had any mental health issues, and luckily until then, but that was a hormonal thing. I sought help, but not everybody has access. Not everybody is aware. And obviously, when it spins out of control, we know that there are dire circumstances that have tragedies like this. I just don't know how the jury's again going to reconcile the mental health aspect with the really, I hate to say, hands-on homicide of these children.
Yeah, absolutely. Dr. Goodman, your final thoughts on this as we get ready to go to our break.
Right. Well, certainly as a criminologist, Julia, I'm very concerned about victimology. So we have many victims in this case. Clearly our 3 deceased children, Patrick himself, the father, the husband, he's a victim. We call it primary, tertiary, secondary victimization. So he's the secondary victim, and tertiary is the rest of us. Society, we just cannot believe the level of heinous, horrific nature of this individual murdering 3 children. But yes, the asterisk has to be examined. The mental health. Did she know what she was doing? Did she know what she was doing is wrong? We know she has a mental health compromise, but did that compromise supersede and take priority and precedent over this gruesome triple homicide?
So many issues at play. Thank you to our panel for helping everyone understand it a little bit better. We have criminal defense attorney David Bruno, forensic pathologist Dr. Priya Banerjee, and criminologist Dr. Debbie Goodman. Thank you all. We are going to take our break as we gear up for that motions hearing, and we'll get you an update out of what's happening there on the ground in Massachusetts. Don't go anywhere.
Welcome to Court TV, your front row seat to justice.
And it could go one way or the other.
I did not kill Maggie. I did not kill Paul.
The defendant's life is hanging in the balance.
Your Honor.
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington, and the Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. All right, so I think we have a motion. Why don't we take up what's a request it's entitled, request by the father of the child victims to restrict display of and access to certain evidence and exhibits at trial to the jury and necessary parties. And what I thought I would do is first hear from counsel for the father, then I'll hear from Commonwealth, I'll hear from the defendant. So, counsel? Yes.
May I approach you?
Yes, please. Thank you.
Judge,
Please state your name for the record.
good afternoon, Your Honor. If it please the court, Ms. Sprague, Ms. Buckingham, Mr. Reddington, my name is David Meyer, M-E-I-E-R, and I appear to the extent that Your Honor allows me to appear on behalf of a potential witness in the case, the father of the 3 victims in the case, Patrick Clancy. If I could, Judge, could I see the court briefly at sidebar?
Sure, absolutely. All right. Counsel, I know we discussed some of the issues here. I don't know if you would want to say anything else for the record in regards to your request.
If I might, very briefly, Your Honor. Again, as I indicated to the court on the record at sidebar and to Ms. Sprague and Ms. Buckingham and Mr. Reddington, thank you, first of all, Judge, for the opportunity to be heard. As everyone is aware, I'm not here as a lawyer representing the Commonwealth, neither am I here as a lawyer in any way representing the defendant. And on behalf of Patrick Clancy, the father of the three child victims in this case, he recognizes, and I recognize on his behalf, that he has no authority, no standing, and no intention of suggesting to this court or to the attorneys how to try their case, how to conduct direct or cross-examination, and perhaps most importantly, what evidence or exhibits should be introduced during the trial. Mr. Clancy, respectfully, Judge, is not seeking to close the courtroom at any time during the trial. Mr. Clancy is not seeking to address the admissibility of any evidence or to exclude any evidence from the jury. And he's not in any way seeking to prejudice the Commonwealth or the defendant in any way. What Mr. Clancy is seeking through counsel, Your Honor, respectfully, is to restrict in a very limited way the display and access to certain specific limited items of evidence and exhibits at trial to the jury, to the court, to counsel, to the court reporter, to the session clerk, and to the court officers. That is, the necessary parties who will be involved in trying the case. And respectfully, Judge, I suggest that pursuant to the so-called Massachusetts Victims' Rights Bill and other statutes and cases with which the court is familiar, as a victim, as a family member of the three victims in this case, Mr. Clancy respectfully has an opportunity and a right to be heard through me or through his counsel. I suggest to the court that certain items of physical evidence or certain exhibits ought be restricted from dissemination and distribution, quite frankly, locally, nationally, and internationally, as is the case in this day and age. And for purposes of this hearing, respectfully, Judge, I would ask the court and I would ask that the record reflect that the recording of the so-called 911 call allegedly made by Mr. Clancy be marked or be included as an exhibit for purposes of this particular request. I would also ask respectfully, Your Honor, that any photographs of the three victims in this case, whether taken prior to the alleged incident, whether so-called scene images, whether photographs or video recordings of the three victims, or any so-called autopsy-related photographs of the victims be marked for purposes of this hearing. Likewise, Your Honor, respectfully, I would ask on behalf of Mr. Clancy that the clothing being worn by the three victims during the course of the alleged incident also be reviewed by the court and marked as exhibits. And lastly, Your Honor, respectfully, given the background that I summarized for the court and counsel on the record at sidebar, I would ask that the material that I have submitted to Your Honor from Patrick Clancy and correspondence that I've shared with both the prosecution and the defense and the court and have submitted to your clerk be also marked as an exhibit, and that it be subject to the motion to impound, which I have filed on behalf of Mr. Clancy, given the nature of that correspondence. In short, Your Honor, I am asking that based on the law, based on Your Honor's ability under the rules of impoundment, and specifically the rule as I understand it on behalf of Mr. Clancy and is cited by Your Honor in your initial order, which I believe is docket number 111, entitled Order Pursuant to Supreme Judicial Court Rule 119, that Your Honor does have the discretion to limit certain recording and certain transmitting of proceedings during the course of a trial. And specifically, as Your Honor knows, that rule, Supreme Judicial Court Rule 119, entitled Electronic Access by the News Media to Court Proceedings, states in one part that a judge may limit or temporarily suspend such access by the news media if it appears that such coverage will create a substantial likelihood of harm to any person or other serious harmful consequence. And the Supreme Judicial Court rule goes on to say a judge may impose other limitations necessary to protect the right of any party to a fair trial or the safety or the well-being of any party, witness, or jury. I suggest to the court that under those provisions, upon reviewing each of those four different categories of potential evidence and the correspondence from Mr. Clancy, that certain limiting rules should be adopted by the court and imposed on the media in this case. Lastly, Judge, I refer the court respectfully to two specific cases in the Commonwealth which respectfully did not rise to the level of the extraordinary nature and facts in this case. One of which, Judge, was a case involving the alleged sexual assault of a young child, which was tried in Middlesex County several years ago. And after the conviction and after the case, a private documentary filmmaker sought access to the recordings of the witnesses who testified in court. And ultimately, the SJC found that the trial court's conclusion that the privacy interests and the emotional harm to the victim and her family outweighed the First Amendment right of the media or a documentary film member to get access to the actual recording live voices in the courtroom. And instead, the SJC, Justice Gantz, indicated that the proper mechanism, given the circumstances of that case, was to allow the documentary film member or the media access to the transcript, that is the written word. Likewise, in that case is Commonwealth versus Winfield, W-I-N-F-I-E-L-D. Similarly, Your Honor, I respectfully direct the court's attention on behalf of Mr. Clancy to a case tried in Essex County, Commonwealth versus Chisholm, C-H-I-S-M, in which then trial judge Lowy heard a motion to suppress when there was a videotape and a recording of a defendant's statement. And ultimately, the media sought access to the videotape statement to disseminate and distribute outside the courtroom. And the SJC ultimately upheld Justice Lowy's decision at the trial court level to allow the media access to a transcript of the videotape and a transcript of the defendant's statements, but not the actual videotape. Given that precedent, given Your Honor's discretion, given the spirit of the Supreme Judicial Court rule that applies to the electronic recordings of proceedings in your courtroom, I end as I began and ask the court on behalf of Mr. Clancy that certain limiting instructions to the media would be appropriate with respect to the 911 recording of Mr. Clancy's voice, certain photographs of the three child victims, and the clothing worn by the three child victims in this case. And again, on behalf of Mr. Clancy, I thank Your Honor for the opportunity to be heard.
All right, counsel, thank you. Attorney Sprague?
Thank you, Your Honor. With regard to the 911 call, Your Honor, I believe it's a public record available at a public records request, but I would defer to the court in terms of how you want to restrict publication of the 911 call during the trial or thereafter, as long as the Commonwealth is still allowed to show or play, rather, the recording for the jury as the court has previously allowed that motion. regarding photographs of the children, we had already addressed the autopsy photographs. The Commonwealth was going to request impoundment of those, and we would agree that they should not be broadcast or photographed in any way. Crime scene photographs, the children had already been removed from the home when the crime scene photographs and video were taken, so they will not appear in those photographs. The only blood in those photographs would be the purported blood of the defendant in the bedroom and on the exterior of the home, and then a small amount of blood from Cora in the basement. In terms of pre-incident photos, there has been mass publication of photos of the children already, but I would defer to the court on that as well. Regarding the clothing of the victims in this case, the clothing would be a shirt and pants that Dawson was wearing, pajamas and a bathrobe that Cora was wearing. There's a small amount of bodily fluid on the pajamas, and then pajamas that Callan was wearing. Although some of the material has been cut as they were cut away from the children, as EMS were working on them, trying to save them, there's nothing about the clothing that I think would suggest the need for restriction of publication of those items. So that's the Commonwealth's opinion.
All right, counsel, thank you. Attorney Reddington?
Let's call a spade, Judge. I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having Patrick Clancy, who's a young man who has suffered one of the worst tragedies that anyone could ever suffer. How that guy is still not an emotional basket case is beyond me, and he has been. But nevertheless, he is trying hard to move on with his life. He has, as the court is aware, they're divorced. He's remarried. He has a family. He has his extended family. Your Honor heard statements, and I know for a fact that it's true, that his family, totally innocent people that have nothing whatsoever to do with this case, are being harassed daily by news media, the New York Post, and all the rest of these types of salacious news media outside their door. This is his family. Some of them are in California. They have nothing to do with this case. But nevertheless, they are being hounded by the media. And the district attorney wants to put that guy on the witness stand and show little onesies with bodily fluid of his child, and they want to have him stand there, or they're going to let him stand in the hallway while we listen to the 911 call.
Mr. Reddington, that's another issue. That's another motion. The question we have right now, respectfully, is Mr. Meyer's request as to how we should deal with this in regards to the media.
I agree with Mr. Meyer's request, as I told you with the sidebar. I think it's very appropriate. I think he argued it effectively. I think that Your Honor is well aware that you have the authority under the SJC rules to enter limiting orders, if you will, as to publication, as to what media can publish, what photographs they could look at and report. And I agree with what he had indicated to you in his argument.
All right. All right.
But I still want to say that I think it's reprehensible the way the government is trying this case.
All right.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
No. I stopped that. And if you want to address that in a different way, then we've got another motion in about 5 minutes that we're going to probably be talking about that. So let's talk about that then. This is I let counsel go and think it was going to wrap back up, and I didn't see that it was going to wrap back up in regards to the request. So that's why I stopped it. All right? This is not accomplishing anything in regards to the question of access to these 4 pieces of evidence. So I've got everybody's position. I've heard the arguments from counsel. What I'm going to do is I'm going to take it under advisement, and then what I'm going to do is issue an order probably tomorrow morning. And parties know I've listened to the tape, that 911 tape. I have looked at the autopsy photographs. I have looked at a crime scene video, which I imagine is where the crime scene pictures will come from. And so I'm familiar with the universe of the evidence that we're dealing with right now. I want to take tonight, go over the arguments from parties. That's why I'm stopped a little bit, everybody. I just want everybody focused on that issue. So I'm going to take this matter, the request of Mr. Clancy under advisement, and I will be issuing an order in regards to that request sometime tomorrow morning. All right? Now, there's one other motion that we have to address, and I believe that is the defendant's motion to limit witnesses. Is that correct? That's the motion we have. All right. Now, what I'm going to, I've read the motion. All right. I've read the grand jury minutes from all the individuals who have scheduled to testify. So I'm going to hear from the defendant just in regards to this, and then I'll hear from the Commonwealth. So, Mr. Reddington.
Thank you. And I will restrict the hyperbole, Your Honor. This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, let's face it, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement. Another firefighter heard noises, was outside. Another firefighter, Duxbury Fire Department EMT, saw Lindsay on the ground, was treating Lindsay, heard screams coming from the house, went into the house, describes the basement scene. Another Pembroke Fire Department individual paramedic, same idea. Another Pembroke Fire Department paramedic was in the house. Duxbury firefighter, EMT, saw the other EMT carrying 2 kids out of the basement, saw 2 children on the floor, described the basement. Marshfield Fire Department paramedic went in the basement, saw the children laying on the floor in the basement, on their backs facing upward. Saw blood, what appeared to be blood around the nose of one of the children. Another firefighter, Marshfield, assisted in the basement, heard the screaming, yelling, and made his observations. Another firefighter from Duxbury in the basement saw the children, little children, wearing onesies and feeties, laying on their backs on the basement floor, assisted as he could. Another Duxbury Fire Department individual, basement. Another Kingston Fire Department mutual aid gentleman, assisted in the basement, describes what he saw in the basement. Another Kingston Fire Department individual saw Pat, heard the screaming, and went downstairs, describes what he saw in the basement. Another Duxbury Fire Department individual responds to the scene, describes the scene, and then Duxbury Fire Department individual responds, saw Patrick in the kitchen, saw him sobbing, and made observations of the scene. So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here, and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves, and it may have worked in the grand jury, but it shouldn't work in a jury trial.
Counsel, is this motion, I understand the rationale behind it, but isn't this motion kind of a little premature? Because I mean, if you're talking about something being cumulative, don't I have to hear what the first witness says first, and then ask for the Commonwealth if there's an offer of proof? There's anything different that this witness saw or did or is going to bring to the jury? And I guess what I'm saying, it's difficult for me sitting here right now to tell the Commonwealth you can't call witness number 2 without knowing what witness number 1 is going to say. I appreciate this kind of flags the issue for me. It's helpful. You know, I went back, I pulled out proposed Rule 403 that talks about, you know, needlessly presenting cumulative evidence, so I could be aware of that. Got the cases pulled out for that. But I don't have everything in front of me. That's what that's the way I was looking at it right now. But Commonwealth.
Thank you, Your Honor. So in a typical murder case with one victim, we would be proving deliberate premeditation and or extreme atrocity or cruelty. Either one of those, proving first-degree murder, you'd have to prove that the defendant's actions caused the death. And the way we do that is with the person finding the body, then the people who treated the body trying to save that person, then the medical staff at the hospital treating them and then declaring them dead, and then the autopsy confirming that the actions of the defendant were the cause of the death. Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you. We don't need that. All right? We don't need that. The question right now for both of you is, this is a motion saying that there's going to be cumulative evidence. I don't know what's going to be presented. So how can I say that witness 2 doesn't bring anything extra after witness 1? I understand the theory. The Commonwealth, and I'm not telling the Commonwealth how to try their case. I'm not. And I guess the issue has been brought up that the defendant views the Commonwealth's approach one way. The Commonwealth views it a different way. I'm the one who's going to have to decide, and I don't have anywhere near enough information right now to determine if something violates, Section 403. But I understand the Commonwealth's position. There are a number of witnesses, and they all may very well bring something unique to the Commonwealth's case. So it's really what I'm probably going to be doing as we go through this is have everybody come over here to the sidebar, hopefully calmly, talking about an offer of proof. And is this witness bringing something? If they do, fine. I'm not restricting the Commonwealth thing. I appreciate the fact that it was brought to my attention. Now I can be aware of it. And we can just deal with it as the trial goes on. Just like, like we said, all of us have tried a number of homicides. So we know how it's done. And so I'm aware of how the Commonwealth has to prove the multiple elements in every case. And so I'll be cognizant of that. So I guess probably just so you'd be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties read. This is exactly why we have motions in eliminate, so I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is, so I'm kind of ready for that as well. So I'm not going to take any action on that motion in eliminate. Like I said, I'm sure we'll be talking about that a little bit later. Anything else we need to address today? Counsel?
No, Your Honor.
All right, defendant?
No.
All right, so the plan, we're going to be in recess on this matter until Monday. Parties should be prepared to give openings. I'll give a very brief pre-charge at that point, and then we will just begin with the evidence, hopefully Monday morning. And I will try to get that order out in regards to Mr. Clancy's request sometime tomorrow morning. All right. So again, I want to thank everybody for kind of helping me get through these issues today, and thank you for all your hard work on this. So we'll be in recess until Monday morning on this.
All right.
This matter is continued to Monday, July 27th, 2026 at 9 a.m. for the jury trial.
Please clear the courtroom, please. Thank you.
Are you going to go into the